HR Basics is a series of short courses designed to highlight what you need to know about a particular human resource management topic. In today's HR Basics, we explore discrimination, first understanding what discrimination is, and then discussing discriminatory practices in the workplace. Let's define discrimination as the unjust or prejudicial treatment of different categories of people. In this course, we seek to understand discrimination and anti-discrimination practices of employers and then discuss 4 types of discrimination that occur in the workplace. Employment discrimination is a form of discrimination based on protected characteristics by employers. Anti-discrimination law protects the right of people to be treated equally. The primary objective of anti-discrimination legislation is to ensure that individuals are given an equal opportunity in the workplace. 2 agencies oversee equal employment regulations. The Equal Employment Opportunity Commission, or EEOC, is responsible for developing guidelines and overseeing compliance with most anti-discrimination laws. And the Office of Federal Contract Compliance, or OFCCP, is responsible for the same activities relative to executive orders. A protected class is a group of people with a common characteristic who are legally protected from employment discrimination on the basis of that characteristic. These traits are called protected characteristics and referred to as protected classes. Protected classes are created both by federal and state law. For more information about state-specific protected classes, check with your state department responsible for anti-discrimination. Federal protected classes include race, color, religion, national origin, sex, age, physical or mental disability, veteran status, genetic information, and citizenship. Title VII of the Civil Rights Act prohibits employment discrimination on the basis of race, color, religion, national origin, and sex in any aspect of employment. Nearly all employers are covered by Title VII of the Civil Rights Act. This includes federal, state, and local governments, as well as private employers with at least 15 employees. Title VII protects all applicants and all current employees of a covered employer. So let's define each of the 5 Title VII protected classes in a little bit more detail. Race discrimination involves treating someone unfavorably because they are of a certain race or because of personal characteristics associated with that race. Color discrimination involves treating someone unfavorably because of skin color complexion. Religious discrimination involves treating a person unfavorably because of his or her sincerely held religious beliefs. National origin discrimination involves treating people unfavorably because they're from a particular country or part of the world or ethnicity, or they appear to be even if they're not. Finally, sex discrimination involves treating someone unfavorably because of that person's sex or gender. Statutory law has created additional anti-discrimination regulation that protect the following. Age discrimination involves treating someone less favorably because of his or her age, over the age of 40. Disability discrimination is when a person with a disability, either physical or mental, is treated less favorably than a person without a disability in same or similar circumstances. Veteran status discrimination involves treating someone less favorably on the basis of their military status or military obligations. Genetic information discrimination involves treating an individual unfairly because of differences in their DNA that may affect their health. And finally, citizenship discrimination involves treating people unfavorably based on immigration or citizenship status. The law allows for employment considerations through what's known as a bona fide occupational qualification exception, a BFOQ. A BFOQ exists in narrow circumstances when a protected characteristic can legally be used to make an employment decision. A BFOQ requires a business necessity, which includes a relationship to legitimate business goals that are essential to business survival. It's important to understand, however, that employers can never use race or skin color as a BFOQ. To prove a bona fide occupational qualification defense, an employer must have 3 elements. First, show a direct relationship between the protected trait and the ability to perform the duties of the job. Second, the BFOQ relates to the essence or central mission of the business or organization. And finally, that there's no less restrictive or reasonable alternative. One of the best ways to understand BFOQ exceptions is to look at examples where the courts have allowed what would otherwise be considered discriminatory. First, how about mandatory retirement ages for public and mass transit drivers and pilots? Or churches who can legally hire only members of their church and reject clergy from other religions? Finally, actors and models of a particular protected class are used for the purposes of authenticity. Anti-discrimination laws outlaw employment discrimination on the basis of the protected characteristics that we discussed in any aspect of employment, from hiring to firing and everything in between. However, discrimination continues to happen in the workplace. Employers have the responsibility to apply anti-discrimination standards to ensure fair and equitable treatment of their employees. Discriminatory practices can typically be grouped under one of four categories. First, disparate treatment, where an individual is treated differently because of the characteristic that defines the protected class. Second, disparate impact, a more subtle and usually unintentional form, also known as adverse impact. Third, harassment, which is unwanted and unwelcome treatment because of a protected class. And finally, retaliation, where employers are prohibited from retaliating against an employee for making a complaint of harassment or discrimination. In disparate treatment cases, an individual is intentionally treated differently because of the characteristic that defines the protected class. Disparate treatment means that the employer intentionally discriminated against a person or persons because of the characteristic. Not hiring a qualified woman simply because she's a female would be obvious and intentional discrimination. An individual who believes that he or she has been the victim of disparate treatment must make a prima facie case or preliminary case using the McDonnell-Douglas test. To make a case of disparate treatment, the plaintiff, the employee, must show all of the following. First, that he or she is a member of a protected class, that he or she applied for a job or another employment opportunity, such as a raise or a promotion, and was qualified. Third, that he or she was rejected. And fourth, that someone else got the job, or the employer continued to seek applications from individuals with the plaintiff's, the employee's, qualifications. The burden of proof then shifts to the employer to provide a legitimate, job-related reason for the decision. For instance, the employer might show that the person selected had more relevant experience or performed better on selection measures. Discrimination may also take a more subtle and unintentional form known as disparate impact or adverse impact. Disparate impact refers to employment practices that appear neutral but have a discriminatory effect on a protected group. Disparate impact may occur in hiring, promotion, training and development, transfer, layoff, and even performance appraisals. The 4/5 rule, known sometimes as the 80% rule, is the simplest and most common way of estimating disparate impact. This test compares the rates of selection for lesser represented classes of individuals against the rate at which the most represented group is selected. If any lesser represented group has a rate that's less than 4/5, 80%, of the rate of the most represented group, this can be used as evidence of discrimination. There are 5 steps to determining adverse impact using the 4/5 rule. First, identify the policy or practice at issue. Second, calculate the rate of selection for each group. Third, note which group has the highest selection rate. Fourth, calculate the adverse impact ratio. And fifth, determine if adverse impact exists. Let's take a look. So here's an example of how to calculate the 4/5 rule. In this scenario, we have 80 white applicants, 48 of which were hired. There were 40 black applicants, 12 of which were hired. So the selection rate of white applicants is 48 divided by 80, or 0.6, which is 60%. White applicants were the group with the highest selection rate. The selection rate of black applicants is 12 divided by 40, or 0.3, which is 30%. The impact ratio, therefore, is calculated as 0.3 divided by 0.6, which equals 0.5, or 50%. So the impact ratio of 50% is less than 80%, which is evidence that based on the 4/5 rule, there might be adverse impact. Title VII also prohibits harassment based on a protected characteristic, although the term harassment does not appear in the law. The type of harassment that you probably are most familiar with in the workplace is sexual harassment. However, unwanted and unwelcome treatment because of race, color, religion, sex, national origin, Age, disability, or genetic information are all forms of harassment. Employers must develop strategies for preventing and correcting harassment in the workplace. Whatever form it takes, prevention is the best tool to eliminate harassment, and it must be a priority for the employer to step in and stop it when it happens. Taking steps to eliminate harassment in the workplace promotes a healthy and productive work environment, and helps defend an employer against the liability of unlawful harassment. Prevention is the best tool to eliminate harassment in the workplace. Swift corrective action restores a positive work environment when harassment occurs. Title VII also prohibits employers from retaliating against an employee for making a complaint of harassment or discrimination, whether internally, to a government agency, or in a lawsuit. Participating in an investigation or other proceeding, or otherwise opposing harassment and discrimination. Retaliation occurs when an employer takes adverse action against an employee who's filed a complaint of discrimination. Retaliation can take on many forms, including but not limited to the following: denying a promotion to an employee who's otherwise qualified, demoting an employee, suspending the employee for a period of time, writing a negative evaluation of the employee, and/or threatening the employee if a complaint is not withdrawn. It's the employer's obligation to understand and identify discrimination and take anti-discrimination steps to prevent and correct protected class discrimination in the workplace.